All right, let's go on the record. 19 CF 7518, I have counsel with State Defense. Mr. Quiles present. I do have copies of the finalized verdict forms and jury instructions. Now that everyone has seen a finalized copy, are there any objections from the state or from the defense? I'll first go to the state.
Yes, sir, Judge. After thinking over the break about that category 2 lesser on count 3, the lewd, the state is now going to put our position on the record that we believe it should just be not given. We were going to ask that it be struck, and I believe the defense will agree.
Not give the lesser?
We're asking now that the court not give the category 2 lesser of the lewd on count 3.
Okay, well then that changes the jury instructions.
We're asking that it all be struck with respect to any lesser as to that count. Because we believe, Judge, just to put our position on the record, if they believe any of those acts occurred when she's 16, that actually changes the charge to unlawful sexual activity. And then we'd have to define that. They'd have to make findings as to dates.
Okay, I see what you're saying.
And the state's conceding that one date where we'll be arguing there was PVI was backdating the conception date from the December 13th appointment to July 7th. That was when she was 15. So we know we're not going to be able to argue what dates PVI occurred otherwise. So our position is not to give that lesser, to make the jury have to make findings of dates when we won't even be able to argue other than the July 7th date.
It's a category 2, so defense, are you in agreement with not giving it then?
We are, because it would, in speaking with Mr. Skinner, it would create some issues.
Okay, that's fine. So what I'm going to do is I'm just going to remove those 2 pages from the jury instructions. What I do need, though, is a new verdict form for count 3. And I'm fine getting that later on this afternoon during a break. That's not an urgent request. But the jury instructions, though, will then be correct because I just removed those 2 pages. Verdict forms for count 1 and 2 remain the same, and actually, an amended one for count 3. We'll take care of that at a break, though. Is there anything else we need to take care of prior to the jury coming in first from the state?
Your Honor, may I just check my PowerPoint, make sure those slides are out? And other than that, we're ready.
Anything from the defense perspective?
No, Your Honor.
Okay, and just to be clear, since we're now taking out that lesser, the defendant is in agreement with the lessers for counts 1 and 2, which we talked about, and then not having any lessers for count 3.
Correct.
Okay.
As much as I'd like the lesser for count 3, I think it creates an issue.
Understood.
All good, Your Honor.
But with that, though, your client's in agreement with not having it.
Judge, I actually was speaking with Mr. Skinner. Let me explain to my client why.
Okay.
Judge, we have consulted with our client. He understands it as an agreement.
Mr. Quiles, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? Yes. All right, so you can put your hand down. So you were present the entire time we went over the jury instructions and the verdict forms in this case. Do you have a full understanding as to what's being read to the jury at this point?
Yes. You
understand the charges and any lesser included crimes being read to the jury for all 3 counts of the indictment? Okay, are you in agreement with not having any lesser included charges read to the jury for the sexual battery count 3? And then you're in agreement with second-degree murder and manslaughter with a firearm being read to the jury for counts 1 and 2? Okay, and your attorney's been able to answer all your questions in that regard?
Yes.
Anything else you want me to inquire about?
From the defense, Your Honor.
Okay, before the jury comes in, I give this instruction in every case I handle. I've sat through the trial. I know the facts of the case very well at this point. If you don't want an attorney or opposing counsel to object during your closing, don't give them a reason to. Stick to the facts of the case. Stick to inferences and arguments that arise from those facts. If you go beyond that and there is an objection, I will sustain it. I will not give the jury the perfunctory rely upon your own memory. I will sustain the objection and I will tell you to move on. So if you don't want a party to object to your closing, don't give them a reason to. That said, please bring the jury back in. Ladies and gentlemen, welcome back. You guys may have a seat. Members of the jury, both the state and the defendant have now rested their respective cases. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. Just to kind of give you guys an idea of the schedule, the state will give their closing argument. I will then give you guys a break. After the break, the defense will have a chance to give you their closing argument. After the defense, the state can give their rebuttal. Whether I give you a break after the defense closing or after the state's rebuttal close, I'll see on timing wise. After they're done, I will then charge you on the law in this case. Depending on what time arguments finish, I will charge you tonight and you'll begin deliberations, or I'll charge you tomorrow morning and you'll begin deliberations. If it's before 4:30, and I expect it to be, I will charge you tonight and you'll begin deliberations. However, we'll be here as late as you guys want us to be tonight. We'll leave whenever you guys want us to leave tonight, and we have all day tomorrow, and we'll see what happens. So there's no time constraint. At that point, it's up to you guys. I can order dinner tonight. We'll talk about that later. But if I do charge you towards the end of the business of the afternoon today, we will do whatever you guys want us to do tonight, going into tomorrow. With that said, State, you have the floor.
May it please the court?
Yes, ma'am.
Defense?
I forget you're carrying our child, and you're oversensitive. I'll kill you and cry. You're stuck with me until you die. Shot her in the head? No. Heart. She just went into a bag. Several bags? No, 2. Just folded her. You know, adrenaline of strength of 10 men. She was dead. Her body went into a dumpster. I'm hoping the holiday and the rain will help at that landfill. That houses will be built over her by the time anyone realizes. Ladies and gentlemen of the jury, Mr. Skinner and myself, we appreciate the time and attention that you all have given during the trial portion, which I know we are on day 6. It's been long. It's been a lot before you all, and you all are going to be tasked with weighing the evidence that's been presented over the past 6 days, the law that your honor will instruct you after closing arguments, and I'll touch upon that in some of it during my closing, and then common sense. And that is when we are going to ask you all, and something you heard all the way back just about 10 days ago. Hold on 1 second. Stop. Sometimes you have to get just a little closer. What does everyone have to do unanimously? Again, this was brought up even during jury selection. Did a crime occur? Was the defendant the one who committed the crime? And again, we have talked about the law, the evidence, and using your common sense. Now, of course, that is simplified. And I'm about to go over the material elements, because I know Mr. Skinner had talked about that as well during jury selection, that every crime here in the state of Florida has elements. And that is what the state of Florida has to prove beyond every reasonable doubt, are those elements, not additional elements, but those elements. And it also, in this case, we have charged 3 crimes. So we're first going to talk about date and venue. I know throughout the trial, you all heard, is that in Duval County, Florida? That is part of the state's requirement to prove that a case occurred here within this jurisdiction. So that is why you all kept hearing, is that in Duval County? That is why. We have 2 different venues. We are stating for counts 1 and 2 that the venue of the murder of Ayanna and her unborn child was at Ace Pick-A-Part off of North Main Street. And I have put an image on the screen, which is State 67. Then I'm going to show you some photographs a little bit later on. We believe, and we are going to argue, that the venue then for count 3, involving the sexual battery, occurred at the defendant's residence. And I'll talk about that testimony. And that would have been during the time frame, because it's different. So we have December 19th through 20th, 2018 for counts 1 and 2. In count 3, we have a larger range based upon the nature of the case, that chart, specifically the sexual battery. That it occurred on or between, on one or more occasion during December 1st, 2017, and then up through December 20th, 2018. So that is why you all will see the different dates during your jury instructions. So, roadmap. I'm just going to briefly touch upon justifiable excusable homicide, and obviously we don't have attempted homicide in this case, so I apologize for that one. I'm just going to brush through it because it's a standard requirement in your jury instructions, and so I just want to point it out, that's not the case in this one today, ladies and gentlemen. You can look at it, but you can move on, because I submit to you there is no evidence before you all to consider that the murder of Ayanna and her unborn child was justified or excused. But again, it's part of the norm requirements, that's why I always like to touch upon it. The elements of our crimes charged, lesser included crimes, and then the evidence that the state is going to argue, we believe, shows the defendant is guilty of these crimes beyond a reasonable doubt. And I apologize, it's an issue with the clicker. So again, when thinking about the evidence, what is not beyond a reasonable doubt? Speculative doubt, imaginary doubt, forced doubt, a mere possible doubt. Those are not reasonable. And if those start to occur, you need to wipe that away, because that is not reasonable doubt. So again, I told you all that we would bring, can you go back just one, two minutes? Thank you. So again, this is about the introduction where it's talking about the justifiable, the excusable, and again, I'm going to go through this very quickly. I'm not reading this to you. Again, it's just to address. Again, no evidence of justified or excused. You can just go next couple. All right. So we have 3 crimes charged before you all. And each verdict of each count should not affect the other one. Because we have brought before you 3 charges that involve the same set of facts. So each charge needs to be determined by you all independently of the other. And that is the reason why, and Your Honor will instruct you on this as well. Thank you, sir. So, what does the state of Florida have to prove in murder in the first degree? So I'm just going to touch upon them, and then later on, at the end of my presentation, I'm going to show you how we have done that. And what I've done, since counts 1 and 2 are identical except for element 1, and that involves who is the victim alleged in that element. So element 1, is IS dead? Is her unborn child dead? Was the death of IS and or her unborn child caused by the criminal acts of the defendant? Was there premeditated killing of IS and her unborn child, meaning that there was premeditated killing? Now, so in thinking about killing with premeditation, there is no time requirement in the state of Florida. When Your Honor instructs you, it's not going to say, has to be 10 minutes, has to be 1 month, has to be 1 year. It could be as simple as a snap of a finger. The person has to have the intent to kill at the time of the killing. But again, so I always want to point that out, because sometimes through watching TV, etc., just rely on the law that Your Honor provides. But there is no time requirement in the state of Florida. However, they have to have that intent at the time they kill. And again, this would be some further definitions. So if you all find that the defendant is guilty of count 1 and or 2 as charged, and also lesser included as well regarding a firearm, you would ask then at that point to make a further finding, meaning during the commission of that first-degree murder, did the defendant actually possess and discharge a firearm, actually possess and discharge a firearm with great bodily harm or death, actually possess a firearm, or did not possess a firearm. So that would be a further finding if you found as charged to murder in the first degree, and you would actually ask to do that as well under murder in the second degree, which is a lesser included crime of first degree. And there's another further finding under manslaughter, but we'll get to that. It's a tad different from the further finding if you get to that point, which we believe you all will under counts 1 and 2. Again, now, Your Honor is also going to instruct you. You all, if you believe the state of Florida has proven beyond a reasonable doubt, it is to the highest crime that you all should find the defendant guilty for. Okay. So what are some of the lesser includeds here? So it's like a building block. It's like that funnel. You start off with the lowest layer, and then the layer comes up like in an opposite triangle. Because when you start out with manslaughter, it's not to the same degree of elements. In fact, it's only 2 elements. It's a different degree of intent. And then you get to second degree. The difference between second degree murder and first degree murder is premeditation. So second degree murder does not require premeditation. So the elements is the same as first-degree murder, dead. Criminal act is the same. But again, it comes down to element 3, that's the difference. First-degree murder, premeditation. And then in second-degree murder, it talks about a depraved mind, demonstrating a disregard for human life. So when an individual decides, I'm going to shoot my gun in a crowd of individuals, not intending to kill one specific person, that could be second-degree murder. Because I intentionally decided I was going to fire that gun. These are some definitions as well that Your Honor instructed you to help you in making your determination. And then like we're talking about that building block, manslaughter is only 2. Again, element 1 is the same, that the individual is dead. And then it's intentionally committed an act or acts that cause the death. Does not require premeditation, does not require that depraved mind. And the further finding, like I stated, that's a tad different, but it's still involving the firearm. In that instance is whether the person carried, displayed, used, threatened to use a firearm, if you all were to find that lesser included crime of manslaughter. Sexual battery. There are 3 elements in regards to sexual battery. That defendant engaged in any act that constituted sexual battery. Sexual battery is the sexual organ of the defendant penetrated or had union with the female genitals of IS. Go back just a second. Thank you. So, in regards to this one, I submit to you 2 is easy. And why? It says IS was 12 years of age or older, younger than 18. There has been 0 dispute that during the 2017 December to December 2018, she was of the age of 15 and 16 years old. Therefore, state has proven beyond reasonable doubt. There's no dispute about her age. Element 3. Again, I submit there is no dispute about element 3. That the defendant was in a familial relationship with her. He was her uncle. So it comes down to, I submit you all, element 1. Whether you all believe that the state of Florida has proven beyond a reasonable doubt the sexual battery, the actual physical act of that penetration. Again, we'll talk about that later. Go ahead. You go ahead. I think there's 3 total. Thank you, sir. So again, these are some of the things that Your Honor is going to instruct you when you're thinking about the witnesses from the stand. Because you can believe all of someone's testimony, some of someone's testimony, or none. That is each of your province of being a fact finder on this jury. Talks about opportunity to see and know things, accurate memory, honest and straightforward with the attorney's questions. I think there's 3 as well. Thank you, Mr. Skinner. Interest in how the case should be decided. Does the testimony agree with other witnesses? Was there an inconsistent statement? So, there was a lot of witnesses that came before you all. I'm not going to stand up here and go through all of them. You all have had 6 days to think about what everyone has stated. You got plenty of time, and then go back and think about also what they stated. But I just kind of wanted to break down who's actually been before you all the past 6 days. Well, family, Kimberly Mobley, Willie Sawyer, we got dad, we got mom, Juanella Haynes, maternal grandmother, Nancy Ware, paternal grandmother, Samaya Sawyer, SS, her sister. And then we got aunts, right? Jametta Mobley, Margie Mobley. And then we know Naomi Mobley, ex-wife of the defendant, and also aunt to IS. We had some friends called. As you all learned, that IS had a very close knit of friends, either from elementary school or middle school. Because again, she was only IS, a 10th grader at the time that this happened. Work-related, we have, of course, the Ace Pickle Park situation with Johnathan Lindros Gary Lindros. We've got Billy Brown with All-American Garbage at the time. We have Ed Schmafeld with the Otis Road landfill that we'll talk about. Then we had a series of law enforcement. We had Detective Abbott, the lead homicide detective. We had Detective Lillard at the time, the lead crime scene detective. Detective Lane, who did the Don Quay and the parsley from IS and SS bedroom on India Avenue. Detective Savage, who did the swabbing of those bottles. Detective Bidlick, who was a part of the homicide team that conducted this investigation, and he was the one tasked with putting the wire on and getting that situated with Morris McClendon. Detective Hamilton, she had gone to 2 different locations. She had gone to Ace Pickup Park to look at that GMC Envoy. She also went to the defendant's residence at Trout River Road to get that 9mm firearm. Detective King, he came in from Ocala with his canine, Knox, and he went to Ace Pickup Park. He also went to the landfill several days as well and told us about that and the alerts that Knox had, and we saw photographs as well. Detective Quintana, the purpose of him, ladies and gentlemen, obviously it was very brief when he took the stand, but it was important that we got the state of Florida to get this information out, that when they get records from a company, and they put these records on these platforms like Cellbrite, Oxygen, that those records are not altered. That's important. They're not changed. They are as is at the time the data is received and downloaded. Officer Harris, she was with the Duval County School Board Police. She was the one that assisted with the video surveillance and looking into if anyone has seen or talked to IS from school when she went that fateful day in December 19th, almost 5 years ago. And then we have Detective Porter. She's the one that commenced the JSO aspect of missing persons investigation on December 21st and all the actions that she did. Experts, you heard from Nicholas Kutu regarding the DNA efforts made by JSO. You heard from Dr. Thomas, how she had done a sexual assault kit with IS. The irony of that, ladies and gentlemen, that would be reported in March 2018 involving a neighbor who was 20. And then DNA results just so happened to come back to the defendant and her interior crotch panties. What a surprise. Put it in for a 20-year-old and we get back a 30-something-year-old who's your uncle. The irony. And another thing we also heard that was interesting from Dr. Thomas is that potential injury to the hymen, indicative of prior sexual activity. And then we heard from Laura Draga, just again to state that the firearm operated, and she also made a noteworthy, the fire was extremely oily, consistent with overcleaning. And then you heard from Dr. Atchu. She was the one that met with IS on December 13th, 2018. And that's when the bomb was about to explode, because there were no more secrets. There were no more hiding. The IS was in fact pregnant. And not just pregnant, but 5 months. It's on. Who's that father? Then we heard about confessions. We'll get into those. Damien Hatch, an inmate. George Jackson, inmate. Cousins with Morris McClendon. And then obviously the defendant's brother, Joseph Quiles. We heard from a bunch of different people regarding records. Nicole Phillips with Navy Federal Credit Union. Jack Brown with Chick-fil-A. Anthony Knitsch with Verizon. Ryan Nestor with the public safety analyst supervisor. Barbara Johnson, who was with the owner of Gun Gallery back at that time. Susan Johnson, the T-Mobile records. And then we heard this morning, actually, from a couple of defense witnesses. So we heard from Kamar Humphrey. Again, Kamar Humphrey was the neighbor. He had sex with IS when she was 15. State of Florida, someone under the age of 16, not equal to, but under the age, cannot consent with someone over the age of 20, equal to 24 and over. And that's what we had here with Kamar Humphrey. We had a 20-year-old and a 15-year-old, and it was illegal. And Ms. Mobley called. Again, following through and trying to protect her daughter. I submit to you that Mr. Humphrey was afraid during that deposition, thinking it was going in some way make him be criminally liable again. There's been zero evidence put before you all. Zero. I submit to you that that would be speculative, forced, imaginary, or mere possible, which all four are not beyond a reasonable doubt. Zero evidence that Kamar Humphrey is involved in this case. And Carol Clipp, a good Samaritan, trying to help. And thankfully we have people like that in our community. But I submit to you all that seeing someone almost at nighttime while you're driving for 5 to 7 seconds, she was just mistaken, but trying to help. Ulysses Dixon, he's a 5-time convicted felon. He's known defendant now for several years, and he has 13 pending charges. And it's just a coincidence. He's charged with human trafficking and sexual battery. So I submit to you all, again, it's up to you all to find if you believe him to be credible or not. Now, physical evidence. We've gone over the witnesses a little bit. We've got the firearm. We've got crime scene photographs. We've got video surveillance from Terry Parker. Cell phone records, either from T-Mobile, Verizon, because we never were able to get IS's phone, as was told to Johnathan Quiles. The defendant threw it in a body of water. But we were able to get the defendant's phone and do what's called a cell dump. The Ace pick-apart video, her bank records, Snapchat records, Google location data of the defendant, the Don Quay and the parsley pills, the khaki bra that Miss Mobley identified, the pink bra that Miss Mobley and SS identified, the Phillips panties that was identified, the Terry Parker book. Now, it's true, ladies and gentlemen. We cannot say 100% that that book came from IS because there was no record at Terry Parker who took that out. And no witnesses stated, I know for a fact. But it was a coincidence. Out of all the high schools, middle schools, elementary schools, all of Duval County, it's a book from Terry Parker High School, the same school where IS was last seen. We've got the rain suit. We've got the sexual assault kit, the Amazon purchase records, the defendant's timesheet, the DNA from that sex kit, and then the wire. Now, this is just an image from Stage 25. Sadly, this is the last time at approximately 11 a.m. on 12/19/2018 that she is seen alive. And we know by looking at that, again, if you see something different, ladies and gentlemen, in any of these photographs, any of those video surveillance, you rely on what you believe you see, if it's different from what I am stating and arguing to you all. She's on the phone. That call, I submit to you all, is not on her Verizon records. And what did we hear from Mr. Knetch? You can go to a third-party app and make a call on that app and it not show up on the Verizon records. And I submit to you all that shows the planning. Don't want to be tracked. why else use a third-party app when you have a phone? That planning had commenced before she made that phone call, before she left school. The van. This is the van that the defendant was driving during this time frame. This is the van that would fit all the kids. This is States 21 composite. This is the van that the defendant was driving the day IS went missing. This is the van that had been used to take them to the beach, etc. And oddly enough, that van gets sold 9 days later, when that's the vehicle that your family uses the most. Now, I agree, and we concede, and we understand. That vehicle was processed. Detective Abbott found it. He got his crime scene detective there. They went there. They processed it, and they found nothing. But again, I submit to you the timing. Talk about coincidences. At some point, those coincidences aren't just coincidences. We talked about the venue in regards to count 3. This is our venue locations on our 16th Street and Trout River Road, where the defendant had lived with his ex-wife, Naomi, during the 2017 and 2018 time frame. And next, this is just a screenshot. So I'm going to talk a little bit about the ACE video. You heard that the ACE video is approximately anywhere from 4 to 5 hours off. Do not know exactly if it's 4, 4:15, 4:30, 4:45, or 5. But we believe comfortably that it's between the 4 and 5. So if we see that 12:53:30, that means it's anywhere from 7:53 a.m. to 8:53 a.m. that the defendant is arriving at work on 12/19/18. And what I did, ladies and gentlemen, State of Florida had shown during its case in chief part of a merged document to kind of get an understanding. However, within that same exhibit is the actual individual clips that had the time. So as indicated on my PowerPoint is the time associated with this clip, which is 12:53:30. And this clip is a Channel 8 video. So the next thing we know, and if you'll help put one more time, thank you, sir. I'm now playing 15:17:41. So we are now approximately between 10:17 a.m. and 11:17 a.m. And we see the defendant leaving. Even though he had told Detective Abbott, I never left work that day. Even though he put on his timesheet, that indicates I never left that day. And just happens to be during the time frame that IS leaves school. Again, coincidences adding up. And two, the reason why I was saying about the 4 to 5, because what we know for sure, this is the correct time on the Google location data, where the defendant, if you'll hit play, sir, thank you. We know that between 11:15 and 11:39, that the defendant is going to that parts store location near the airport. And you also heard from Detective Abbott that he drove these locations. He said it was approximately, depending on traffic, between a 7 and 8 minute drive one way from around Ace Pickup Park to the parts store. And then he had stated as well that it was like a 38-minute trip, round trip from Terry Parker High School to the area of Terry Parker. And then he stated that that parts store to Terry Parker High School was approximately 18 minutes one way. Another thing we heard about this is that when the almost 11:40, it's 11:39 and some milliseconds after that, that GPS goes off. As you heard from Ryan Nestor, doesn't come back on until 4:04 p.m. the next day again. A coincidence? I submit no. Because you know what also we heard? We heard from Naomi Mobley, defendant's wife. She said, I went back and looked. We always share locations. During that same time frame, he had turned it off. Again, coincidence? I submit no. Next one, please. So thinking about time, just even in reference to what the actual video shows, at 15:17 and some seconds, the defendant leaves. And we only have a video of that 25-minute time frame. Well, the defendant comes back at 16:30. It's gone an hour and 13 minutes. You can hit play. And also, again, make your own observations, but I submit to you the defendant drives back. He drives back in that new area that Ace Pick-Apart has acquired, where that was the old concrete factory where there's no video surveillance. We submit to you, that is when he takes IS back there. Again, he's gone for an hour and 17 minutes, and that GPS Google data only is for 25. So we have 52 more minutes. Another thing we heard that's important about this time frame, Naomi Mobley stated, defendant didn't come home. I didn't go up there to bring him lunch, and he didn't come home. 52 minutes. Again, coincidence? No. Now, did we hit play? Thank you, sir. The defendant then is back in that area where you've heard from the Lindroses. He's not allowed to drive his vehicle back there. I mean, he works back there, but can't drive his vehicle back there. Now we see him finally coming out from that area with no camera surveillance. Go ahead, the next click. 3 minutes and 39 seconds, approximately, is how long he is back in that prohibited area of his vehicle. Go ahead, sir. Now, at 18:46, so again, if we're doing our math, that would be 6 p.m. if we take off the military time, minus the 4, it's around 2:46. If we do the 5, 1:46. So sometime between 1:46 and 2:46, again, the defendant is getting duct tape. Duct tape. Johnathan Lindros was asked, is that something normal for you to have a task to work with? Johnathan Lindros said, no, it's not. And another thing I want to point out to you all, again, if you hear something different, in the wire, defendants asked, were there strings on the bags? The defendant said no. Therefore, submit to you all, a way to get those bags to stay shut, since they have no strings, is duct tape. Now, we know that at the end of the day, the defendant leaves at the 22:06 44-second mark that's indicated. So that would either, again, be around the 5 o'clock area or the 6 o'clock area, between those two time frames. Okay. We know that he comes back to Ace Pick-Apart at 12:44:01. And I know that Mr. Lindros had felt more confident with this date probably being closer to the 5-hour minus time frame. So that would be 7:44 approximately in the morning. Now, another thing I just wanted to point out to you all, again, these coincidences. In the 12:19:18 video, the defendant has braids. Naomi Mobley had stated that he would wear his hair in braids, or he also would wear his hair with no braids. But I submit to you that in 12:19:18, the defendant's wearing braids. However, in 12:20:18, no braids. Coincidence? I submit no. Another thing in regards to the video comparisons of 12:19 and 12:20. And again, 12:20, it is raining a lot, pretty heavy. And on this particular day, the only time, and this is also for 12:19, the only time the defendant is seen bring a vehicle from one side where that concrete factory area to the area by the crusher, the area by the container. It's only one time. And that one time is not long before the container arrives. Coincidence? No. That's 1852. Again, it appears to be an older maroon four-door sedan. You'll hit the next one, please. And then, at some point, too, during that day, the defendant gets another rain suit. Submit to you, that's odd. He has a rain suit on. But again, another thing, coincidence? Submit no. And that was just early in the day, and I apologize, it's a little bit out of tune for timing purposes. Then, if you'll hit play, Mr. Skinner, at 1852-53, and I'm going to show you all. It's hard to see in this video because it's covered by parts. However, there is a red blurb right under this red car. That is the edge of the container. I just wanted to point that out. Is it playing, Dan? It's playing now. And in the 1852-53, we're looking at camera angle 11. And in this angle, I'll submit to you all, this is then where we see the defendant bringing that sedan to the area of the container and the car crusher. You'll go to the next one, please. Now, about another 8 to 10 minutes later, the defendant is now in his front loader. Again, he's changed out the forks for the bucket. And Johnathan Lindros even kind of stated, I'm not really sure why he's getting the bucket. Well, in thinking about this at the 1902 approximate time frame, the bucket is actually up. It's not facing forward. So I submit to you, there's something inside that bucket. And this happens shortly after the car is taken. The only car taken in that 2-day time frame. Then, in the next clip, approximate same time frame, at 11, I just did a screenshot, there's video of it. It's taken to the container. And yes, it's the only container on the property, but there's other garbage receptacles closer by. However, this is taken straight to the container. After the container, the bucket, I submit to you all again, you can look at it, is downward. It's not upward. Now, in 1908-34, this is where we submit the All-American garbage has arrived. The defendant is in his front loader, and he goes straight to him. Now, this is after he's brought the car over. This is after he's brought something over in the dumps and the bucket. And I submit to you again that he is actually not walking, but in a hurry to get to that driver. We can move on. Now, submit to you, you'll see him get back in, and then next, he then will take them to the location of where the container is to swap them out. I submit in the first one is a screenshot from 1912-52, where again, if you look closely, you can see the red container coming down at an angle to actually slide off. You can see that in the video. And then the All-American is clearly displayed at the 1921-05 time frame, exiting the property. Camera view 5 at 1921-32. Is it? The All-American container is seen exiting the property. And it's a state submission that that's when IS is exiting the property. Next, please. Now that time frame, 1921, was when we saw All-American container leaving. 24 minutes later, who do we see leaving? Will you hit play, sir? However, he doesn't go straight out. He goes back. I submit he's going back to make sure he's got everything taken care of. Nothing left. Hit the next, please. And then what do we learn? We learn that he goes to the gun gallery where his ex-wife had identified his signature. And it's on line 10. Now, something else that was kind of interesting about the gun gallery. The GPS Google location data comes up. But what also did we hear? We heard from his ex-wife, they always go to the gun range. So I submit to you, is it a coincidence that you're putting in GPS when you always go somewhere? I submit to you, wouldn't you know the address? Again, coincidence? No. The defendant talks about going to the gun gallery in the wire to his brother. Somehow thinking if they can figure out this gun's been shot recently, well then I submit to you our argument is, well, I went to the gun gallery, I just shot it. You saw my Google location data, I went there. Again, coincidence, part of the plan. Timesheet, another not coincidence. That Ace video refutes that timesheet, refutes what he told Detective Abbott back in December of 2018 when he first met him. Refutes. Well, the next question would be, well, why did he then go to a parts store? I submit to you plan B. They find out that I leave. I went to a parts store. Mr. Linders asked me to go. But then it still doesn't add up. Because we still have 52 minutes unaccounted for with no location data that's been taken off. The gun. The defendant says in the wire, I used the gun at my house. The police haven't even gone and get it. He even says it's a 9mm firearm. Police go to the house, do a search warrant, they get it. So we submit to you this is our murder weapon. Now the landfill, yes, it was a lot. But that's what JSO did. They were 16 grueling days at that landfill. Did they find her remains? No. But what did we hear? What did we see? And just so you know, the picture on the left is from day 1. The picture on the right is from day 16. What was it? Over 5,500 tons JSO went through. But again, needle in a haystack, looking for her. We saw the vultures, indicative of remains. We had the canine out there, Knox, or alerting as well. Again, needle in a haystack. Okay. We did find some items. Again, we talked about the Terry Parker book. We had the pink bra identified, the lip panties identified, and then we also found some paperwork from Ace Pickle Park during that time frame. Snapchat messages. I just want to point out some of those to you all. Again, we submit those messages are from the defendant and IS. And that IS saved those messages. She was the owner of both accounts. Again, because this is a secret. This is an underage relationship with a niece. This is not something that is wanting to be known. In fact, IS lied until the day she died for him. And what did he do in return? He killed her for her loyalty and love. I'm too jealous with you. I couldn't even sleep last night. I need to separate myself from you. Not yet. I need to calm down. And I put the dates beside them, August 3rd. You know what? I'm going to give you last piece of dick in the AM and cut all ties with you completely. August 7th, 2018. You all and I was getting a divorce, and you and I, once you hit 18, was going to break out. August 7th. I'm not going to have you stay the night anymore. Anyway, so whatever you really did this time, August 7th, 2018, and we know that IS was over there all the time, based upon all the testimony. I love you too. We can't risk your future. I promise I'll give you 2 kids. But you need to finish up college so you can be very successful in life. That's August 14th. You just make it all so easy for me to just leave you alone. Goodbye, Yana. Just like he did between December 19th and December 20th. I think you should take the bus back home from now on. Again, we heard that the defendant would go to that school, pick her up, pick up SS, and then his son when he came. And that's what we heard from Haley Schimper. She had seen the defendant's van there before. And that's what we're hearing right here as well. You seem to have it all figured out. That's August 20th. I don't like nobody hurting you but me. Who did we also hear that the defendant was quite selfish from? Oh, and that text message from the defendant's phone from Joseph Quiles about the selfishness of his brother. I'm sorry, I forgot. You're carrying our child and you're oversensitive. I do love you very much and don't want you to keep going through this drama, but we have plans, and if you act off your emotions, you will hinder our plans in the future. If that doesn't predicate why we're here today. IS hindered the defendant's plans by not having an abortion. It's very hard to see it now, but it's the truth from August 22nd. Again, for only purposes for count 1 and 2, motive, intent, plan, opportunity, absent mistake for count 3, and then motive only for count 1 and 2. He also admits to Maya. Now, there's a thing that could potentially, well, when we listen to The Wire, the defendant says 100%, I never messed with SS. Well, I submit to you that's because he's not going to admit to that because she's alive. He's admitting to IS because he thinks he's going to get away with it because he thinks that there's no evidence. He even says that they got nothing on me. They going to find that body. So I submit to you that he lied about SS because she's alive. She's still around. IS is not. That was August the 23rd. August 26th, LOL, you will be my best friend once you're pregnant. I'll cook for you until you can't eat no more. Again, what do we hear from Naomi, his ex-wife, about the cooking? More corroboration. Next, please. I've been kicked down there so much, I'm not sure how you're even pregnant. From August 29th. So that's interesting. By the end of August, the defendant already knew she was pregnant. Because we know the family doesn't find out till December. August. There's still time for that abortion. Yeah, so I need you to be like 100% with me at all times. I'm just so in love with you. I'll kill you. And cry. That's from 3 months before she's killed. You're stuck with me until you die. How prophetic. Because IS was. She was stuck with him until her final days on this earth. I love you way too much to let you go, so you're not going to have no life. And she doesn't. Now, in going into just highlight a few of the things of The Wire, I know it was 2 hours long, that's why we just wanted to point out a few things. She was 16 when she came out that she was pregnant. It was a possibility that was mine, you know. They already was accusing me of it. Yeah, she got shot. There ain't no ballistics. No, it was just that I got. Everything's clean. No, nothing. I went to the gun range the same day. Taurus, a 9mm. It was a roller dumpster. That's all they got over there as far for garbage. 40-yard. And that's what we heard, is a 40-yard container. Next one. If she had gave birth to that baby, I'd been sitting right here with y'all. Adrenaline give you the strength of 10 men. So the same day she went missing, the same day you dumped her? Well, no, it wasn't. It would be the next day. So where the F you had? You have her the first day. She was dead, man. She was dead. It's loud over where I work at. And this was, I submit, in reference to the gunshot and the noise. Again, part of the planning, part of the preparation, part of that premeditation. You did say you were in the yard. Yeah, and I submit to you that's in reference to where he shot her. And yes, ladies and gentlemen, is there some discrepancy? Was it in the car? Was it outside the car? Yes, it is, but it doesn't change where he's at ultimately, which is Ace Pick-a-Part in a secluded location. Her name was Ayanna. A unique name. She was actually scholarship. She was fixing to graduate 2 years early and go to college. As you heard from Naomi, she was the one that they thought could be president. You think they'll give you... Oh, I'm sorry. I thought I heard something. You think they'll give you the needle? Well, one, that premeditated murder. Two, a young adult with an unborn child that was in 5 months. So they can consider it as like 2. But the only thing that I might have on my side is due to the accumulation of garbage. He's talking about how, well, selfish me. Thank goodness it's the holiday season, so I can get away with this murder even more. This was a holiday. And then with all the rain that we had within those days. You know what I'm saying? Shot her in the head, no. Heart. Yeah, she was dead. She just went into a bath. You poured some water where the blood was? Yeah, no. It's just, it's dirt. You just scoop it up. I can move it. Scoop it up. Y'all fixing to run away? Yeah. You faking it? Yeah. Boy, you, and then the defendant says, slime boy, and shit. Again, with that planning, that premeditation, using that authority over her, that manipulation over her, that is clearly seen in those Snapchat messages, the mental abuse that he has over her, a juvenile. It's your wife's sister's kid? Yeah. She was my little baby. Yeah, been effing how long? probably less than a year. My theory behind it is that since I had no connection to anything, she can sit there for a whole effing year and they'll build houses on top of that. That's how the defendant sees his niece. Shit. Now, in regards to the brother, his biological brother, we know that there was 4 calls on December 20 based upon the records. He was nervous, panicky, concerned. Something I need to do. What is he going to do with the young lady? It's going to ruin his family. The young lady is pregnant. It's his wife's niece. The next call is, took care of that. Had her in the vehicle, strangled her, couldn't stomach it, shot her in the chest. What's also in the chest? The heart. Had her in the, discarded her body, and then transported in that dumpster. Go next. Destroyed the vehicle she was in. Well, what did we see in the video surveillance? We saw one vehicle, 19 to the 20th, being taken by the defendant to the crusher. Shot her in the car, in the chest. She came there on the premises that they were going to run away together and be a couple. That manipulation, that love, that loyalty, taking that secret to her grave. How the defendant repaid her. Wrapped her in carpet, used machinery to do it. That front loader, front and center on that video surveillance. Knew the dumpster was going to be picked up, which it was. Would lose his entire family if his baby was born. Because what do we always hear about Naomi? From Naomi, but all his children look just like him. All. And then went to the shooting range. Planning it for months. She wouldn't have that abortion, I submit to you all. That's one of the reasons why I asked Nicholas Q2, did you do fetal remains? Can you do DNA on paternity? And he said they could. When she wouldn't get that abortion, the defendant was left with the choice of killing her and destroying that evidence. Put her phone in the neighboring water, tried to speak with his brother, see if he changed his story. The brother wouldn't speak to him, so that's when he made the decision to call. Why told? Does not tolerate abusing children and women. So, just kind of getting closer to wrapping up, we also heard about the Don Quay and the parsley, that the defendant had given these to IS and SS, and then Detective Abbott was able to dig into that. He didn't just take the word of Miss Mobley, ISSS. He reached out to Miss Mobley and said, hey, you just checked some accounts to see October of 2017, lo and behold, parsley and Don Quay. And lo and behold, what do we hear? Gives you miscarriages. Now, this is just more specifically in how we proved, and again, coming down here to the wire. Element 1, again, element 1 is the same except for which victim. IS is count 1, unborn child is count 2. Dead. So the reason why the family was called, ladies and gentlemen, and that was to show her world was done. Mom, dad, grandparents, aunts, sister. Nobody has heard from her since she left the high school at 11 a.m. on 12/19. Friends. She's a teenager. Teenagers talk to their friends. That's their life, usually, at that time, is their friends. She never returned to school. She never used another bank charge. She never had another phone communication. She never picked up her checks. Over $150, and it's right before Christmas. A teenager? And then the admissions to the brother, the admissions to the wire, admissions to the hatch. That is why, ladies and gentlemen, we are submitting. We have proven beyond a reasonable doubt, based upon that evidence and the exhibits that corroborate, that IS is not with us. She is dead. And in the defendant's own words, She was dead. Next one. Death was caused by the criminal act. He said he shot her, couldn't stomach it. He was at work, said no cameras. The activities at work regarding the forklift, getting the duct tape, lying about leaving work, turning off the GPS data location between those fateful time frames of 12:19 and 12:20. Cell phone records. His cell dump. He deleted his records from December 2016 through December 20th. Coincidence? No. Container, the landfill, the video from A's, the timesheet. He didn't go home that day. His actions, because what did Miami Mobley also tell us? Before IS went missing on that 12/19, he was fidgety, he was nervous, he was restless, he wasn't getting sleep because he knew she wasn't having an abortion. Because think about that short time frame. He's known since August that she's pregnant. Mom finds out December 3rd. Family finds out December 6th. Accusations by aunt comes December 6th. Baby's confirmed December 13th. And then Ayanna is killed 6 days later. The pressure was on. She turned her phone off. Brother wire hatch Snapchat messages. We submit, this shows that he shot her and what he did with her and why he did it. Now, might be a question. I'll just go ahead and just address this very quickly. Well, we don't know if he was the father of the child. Well, ladies and gentlemen, it doesn't matter. There's not one element under murder in the first degree that says we have to provide by DNA that the defendant was the father. That's not one of those elements. Because if we even think about the defendant's own words, it was the chance alone that the defendant killed. The chance alone. So it doesn't matter if that child ultimately was or was not. We submit to it was, but it doesn't matter. That's not one of the elements. And in the defendant's own eyes and own thoughts, his own statements, the chance alone had him commit pre-planned, premeditated murder for his own selfishness so he would not get caught. Next one. And the last one, the premeditation. Again, we've heard planning about a month. We've heard planning months, pressure on the family. Tricked her to come to work. Said he would even kill in Snapchat. The dates, I already talked about the 3rd, the 6th. Cues, the baby confirmed. Not getting an abortion. The omissions, the Snapchat. Now, in regards to the sexual battery, encourage or entice her to have sex. Well, she's pregnant. Common sense lets you know how a pregnancy occurs. We have the Snapchat messages where he talks about, I've been hit so many times down there. You're carrying our child. You've heard SS state it was the defendant too. You've heard the defendant admit that about the sex and the wire and to his brother as well, and to Hatch. The DNA, the hymen, the limited purposes of SS and ID, as well regarding the motive. The grooming. Like he had told ID, she's the new girl on the block. She just came into the picture in 2017. New niece on the block. I've already had 2 nieces. So are you a virgin? Oh, you sure are pretty. Oh. You know how to put a condom on? That's what you can go further with ID because she didn't allow it. That's the difference. She was older, more mature, different personality than a 13-year-old. All right, next. And at the time, again, so this was another easy one. We talked about age, her date of birth. We heard from mom and sister that she was, thank you, that she was under the age of, it should be 18, I apologize. That should be 18, that's my bad, but we rely on from the law from your honor. She was under the age of 18 at the time. Apologize for that error, it's a big error. But again, the limited purposes, again, for, and I just touch upon this, is the sexual abuse of SS, and ID it for count 1 and 2 motive, and count 3 motive, intent, plan, opportunity, absent, mistake, or accident. Okay, next. Now, did a crime occur, and did the defendant commit the crime? I submit to you, ladies and gentlemen, after hearing all this evidence and seeing all the exhibits, yes, the defendant not only committed 1 crime, but 3. And I talked about in opening how there was going to be a lot of different pieces in this case. And after all these pieces were put together, there was going to be a picture. So let's look at those pieces. The DNA from the crotch and the panties. The 3rd confession that was made to Damian Hatch. The 2nd confession that was made in the wire. Sister Samai, because she sadly was there during one of the defendant's sexual abuse acts on her sister. And also saw different various forms of kissing and touching and groping. She's pregnant. Came from having sex. Cell phone records again. Deleted data, turned off location. Go ahead. Ayana as well, too, turning off her phone. The Snapchat messages. Confirming the relationship, the sex, the nature of the father. Go ahead. The gun. Got that. The donkey and the parsley. Again, not wanting to obviously get an underage niece pregnant. The A's video that contradicts the defendant leaving, but corroborates the defendant's omissions. Google location. The defendant leaves, but we still got 52 minutes unaccounted for. And lastly, what started it all, his brother, Johnathan Quiles. So, ladies and gentlemen, go to the next one. We're asking you for Ayana and the unborn child who is going to be named Hazel to find the defendant guilty of premeditated first-degree murder of IS, she was pregnant with his child, or the chance of being the child, the father of the child. And then also for the unborn child. And we submit to you that the evidence before you is beyond a reasonable doubt, that the sexual battery as well, regarding all the evidence, and find him guilty as charged to all 3 counts. Thank you all.
Members of the jury, I told you I'd give you a break. At the conclusion of the state's first close, I'll do so. It's 1:31. Is 20 minutes enough time? Let's come back at 1:55. We'll go from there. Please remember, don't discuss the case among yourselves or each other. And I'll see you guys then. The jury's outside our presence. You guys may have a seat. I still have counsel of the state defense. Mr. Quiles present. Anything we need to take up before we come back for the defense close? State. What I'll probably do is do the defense close and then go straight to the state's rebuttal close and then give a break at this point. So I'll see you guys in about 23. All right, members of the jury, welcome back. You guys may have a seat. We're going to continue. Now it's the defense's turn for a closing argument, and I'll turn to the defense. Ma'am.
Awesome. Ladies and gentlemen, I always start every closing the same by saying thank you to you. Thank you for your time. Thank you for your attention. This has been a long, almost 2 weeks, And so I just want to take a moment to say thank you. I don't get another opportunity to say that to you. So again, thank you very much for listening, for paying attention, for being on time, for just being excellent at wading through all of this. Question everything. Question and weigh the evidence that you have observed over the last 6 days of testimony. Question what you've been shown. Question what you've heard. Question everything. Why should you question everything about this case? When you look and start to make the determination of whether or not Mr. Quiles is guilty of first-degree premeditated murder, 2 counts, and a 3rd count of sexual battery, you have to make the determination of whether what you've been told has happened and the way that it happened, if that makes sense. So question, weigh that evidence. Does it make sense to you? Are there holes? Are there things that just don't add up? Are you left with questions that lead to reasonable doubt? Let me talk to you about the charges. We'll start there. The charges are first-degree premeditated murder. You've heard from the state. They've gone through this with you, so I'm not going to spend a whole lot of time going through each of those. But I want to just point this out. State told you, we told you, this has been said many times, that each and every element of these crimes has to be proven to each of you beyond and to the exclusion of every reasonable doubt. That's a high standard. That burden of proof lies with the state. They have to prove each of these elements to you in order for you to be able to find Mr. Quiles guilty of anything. The state mentioned some lesser included as it relates to the first 2 counts. You have the option of determining a second-degree murder as a lesser included or manslaughter. And Ms. French did a great job of explaining those differences to you. I'm not saying anything different. The difference between first and second degree is that premeditation. And the judge will instruct you on those details in full at the very end once the state has had their chance to rebut. Listen to those instructions. Think that through. Think through the premeditation portion. Think through what second-degree murder might mean for you if you do not find beyond and to the exclusion of every reasonable doubt that there was premeditation in this crime that they have alleged. Count 3 is sexual battery. Again, this has already been gone through, so I'm not going to spend a whole lot of time. But again, you must find that each and every element has been proven beyond and to the exclusion of every reasonable doubt. So what is reasonable doubt? You were told what it's not, so let me tell you what it is. If after carefully considering and comparing and weighing that evidence, questioning what you've heard, if there's not an abiding conviction of guilt, or if you have that conviction, but it's not stable, if it wavers, if it vacillates, it's not something that you feel is an abiding conviction, that is not a thing that you can find guilty. You must find him not guilty. That would be reasonable doubt. And if you find that there is reasonable doubt, if you are wavering back and forth, if you're not sure, if you're left with those questions that lead to that reasonable doubt in the end, you must find Mr. Quiles not guilty. Now, where can you find reasonable doubt? In what you've heard. The evidence. Conflicts in the evidence. The lack of evidence. I submit to you that all 3 will lead to reasonable doubt in this case. There are conflicts left and right. There are inconsistent statements. There are things that just don't make sense. That is what will lead you to reasonable doubt. We told you at the very beginning that Mr. Quiles was carrying something with him when he walked into this courtroom that very first day of jury selection. We said then, you must presume, you have to presume that he is innocent. And that has stayed with him through every stage of this trial. He is innocent until it's proven beyond and to the exclusion of every reasonable doubt as to every material allegation in the indictment. And that's counts 1, 2, and 3. If that has not been overcome, he is not guilty. Weighing the evidence. This is what you're tasked with. This is what I started off talking with. This is your duty. This is what you have to do. You have to weigh the evidence. It's you. Mr. Davis told you in his opening, you all are the triers of fact. You all determine who's telling the truth and who's not. Just because the state says it so doesn't make it so. It's you all. You all get to decide what evidence is reliable, what evidence should be considered by you, what is the best evidence that's come up. And you heard a few of those things that you can consider when you're weighing the evidence. And those questions that you should ask yourself as you think through the evidence. And I'm going to read a few of them. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering our questions? Was the witness honest? Did that witness have some interest in how this case should be decided? You heard from people who had things to benefit from sitting on that stand and talking to you. Weigh that evidence. Determine if it's credible or not. Determine if that's something you can rely upon. Does the witness's testimony agree with other testimony and other evidence in the case? And finally, did the witness at some other point make a statement that's inconsistent with the testimony that was given in court? I would submit to you that several witnesses changed what was said from before to now and in between. Inconsistencies. This case is rife with them. Who did you hear from? I didn't know that Ms. French was going to do this, but I did a very similar slide of who the family is, just so you could get an idea of the players, who came to talk to you, and to refresh your memory, because I know it's been some time since you've heard from, especially from the very first day, of the people that you heard from that day. So let's go through a few of the things that you heard and give you a few reminders. You heard from the family of IS. You heard from Kimberly Mobley. You heard from Willie Sawyer, mother and father of IS. You heard from Jametta, Margie, and Naomi. Those are aunts. You heard from SS, IS's sister, ID, IS's cousin, and you heard from grandmothers, Winella Haynes and Nancy Ware. One's a maternal, one's the paternal grandmother. The paternal grandmother is the one that lives in Georgia. What did you hear from them that sticks out? What did you hear from them that needs to be considered as you weigh the evidence and make your determination? You heard from Naomi Mobley, Mr. Quiles' ex-wife. And that was just yesterday. She told you that December 6th, the family got into a huge argument about Johnathan Quiles being Jose. She told you that she had heard these rumors among the sisters. It's 5 sisters. It's a lot of girls. That comes with talk. Those sisters started those rumors in early 2018 when Kamar Humphrey sexually battered IS. She told you, Naomi Mobley told you, she confronted her nieces. She said, I went to both of them. I didn't just go to one, I went to both. And I went to them away from Mr. Quiles. They spent a lot of time with her. They were close. She asked them, has there been anything inappropriate, anything of a sexual nature, anything whatsoever at all? They both told her, no, never. He would never do anything like that. Mr. Quiles wasn't around when those denials happened. Mr. Quiles didn't influence that in some way. That was a conversation between an aunt and nieces. And what happened after that? After those accusations first came up in early 2018, did IS, SS, and their two younger brothers stop going to the Quiles home? No. They continued to go to their house. If those rumors had been around and there was any truth to them, if there was any indication that that was actually happening, those children would not have been at Naomi and Uncle John's house. Naomi Mobley herself said she would have taken her child and left him. Those rumors were put to bed because there was no truth in them. Why? Why would Kimberly Mobley continue to allow her children to go to Mr. Quiles' home if she suspected that there was some sexual activity going on, if this rumor had any truth to it whatsoever? Why would Naomi Mobley stay with Mr. Quiles if there was even a modicum of truth to those allegations? I would submit to you that the answer to both of those is no, she would not have. Those kids would not have continued to go there. Let's talk about the Snapchat. Naomi Mobley told you yesterday she knew Mr. Quiles would communicate from time to time with the children on Snapchat. There was no secret. That wasn't something that was being hidden. If he's on the phone, she says, "What are you doing?" He said, "Oh, I'm Snapchatting my niece, Snapchatting so-and-so," or whatever he was doing. He wasn't hiding that from her because there was nothing to hide. What did you hear from SS? She maintained for years after her sister went missing that Mr. Quiles never sent anything on Snapchat that was inappropriate. Just normal conversation. These messages that we saw, we don't know who wrote these messages. We can see that there are messages that are about Mr. Quiles, not from him. We don't know who set that account up, who was using that account regularly, how many people were using that account, who had access to that account. It's a one-sided conversation of some saved messages. The context is not there. It's not complete. You don't know who is on the other end. There are messages contained within there that could be from anyone she was in a relationship with. So who else was she in a relationship with during that time? We've heard from her best friend that she was in love with Kamar Humphrey. She was in love with Jose. That relationship with Kamar went on for months. Her best friend from kindergarten told you that. Jose, she was in a relationship with for quite some time. What did the friends of IS tell you? Alberta Vey, she came and she talked to you all. What did she tell you about Jose, IS's boyfriend? She told you he was Hispanic and black. He was 20 or 21 years old. He lived in Azalea Ridge Apartments. Same apartments that Willie Sawyer, IS's dad, lived in at the time. And she had talked to SS the day that IS went missing and told her, "Hey, Maybe tell your mom about Jose. What did SS say back to her? I don't know what you're talking about. SS didn't know anything about Jose. And what was the last thing that Albertha Vey told you all? She had heard that IS was seen in Azalea Ridge Apartments. What did Willie Sawyer say? Willie Sawyer told you that he heard Jose was there. He let police know. They didn't follow up. They didn't investigate it properly. What did Haley Shempert, the best friend from kindergarten, tell you? She told you about being in love with both Jose and Kamar Humphrey. She also told you Jose wasn't a code name. That was his real name. Albertha told you the same thing. She asked her and said, oh no, Jose is his real name. There were officers who were involved. I'm going to go through a few of those as well. You heard from Detective Porter. Detective Porter went to Mr. Humphrey's job to ask him where he was during the time that IS went missing. He told her that he was in Pennsylvania. They never verified that. They went off of that and they left it there. It wasn't until just a few weeks ago that he provided a bus ticket that shows he was supposed to go to Pennsylvania. But guess what? When I asked him about this, I didn't prompt him. I didn't ask him, oh, were you there from the 18th to the 28th, or were you not there during those days? I said, when did you go out of town? He told me, I was gone from December 21st to the 23rd, and I went there by plane. What aggressive question could possibly cause you to lie like that? Where were you? That's what I asked him. I didn't force him to say that. I didn't badger him. I didn't ask him 10, 12 questions and then get him to trip up and say another date. He volunteered that information. In fact, what he said was, let me check my calendar. He checked his calendar and told us the dates that he was gone was December 21st through the 23rd. Only later, after realizing, oh shoot, let the cat out of the bag, I was in town on the 19th and the 20th, did he go back and produce this bus ticket to show that he wasn't in town. 4.5 years later. The other thing Detective Porter did was try to follow up on some of those leads. Later, once the family finally fesses up to Jose being something that they knew about earlier, Detective Porter asked, hey, why would you not disclose that information to me earlier? Why are you just telling me that now? She asked SS that. Because SS was the only one who could say that Jose could possibly be someone else. She was the only source, the only witness who says that she knows that Jose is Johnathan Quiles. But think what she told Albertha Vey on the day her sister went missing. I don't know anything about Jose. She didn't have that information. She was forced to tell that information. You also heard from Detective King. He's the canine who came and testified. And a lot of the evidence from the landfill, Ace pick-apart, that you all have seen is not related to this case. Has absolutely nothing to do with this case. The hits on that blue GMC Envoy at Ace Pick-a-Part that the Detective King talked about, that's not related to this case. What did Gary Lindros tell you? He thought it was weird. Like, why are you all taking this vehicle? Why are you examining a vehicle that just got here a week ago? This vehicle wasn't even here on the dates that you all are questioning. Waste of time. His hits that he said, the picture that you saw of that dog laying down, that was a picture of a training material, getting ready for the day. Not a hit on something random, not a hit on a body. Detective King found nothing at the landfill that could be sufficiently connected to IS via DNA or anything along those lines. The evidence technician, Officer Lillard, they never located a body. They located some items, again, never connected to IS via DNA or anything along those lines. They talk about some underwear. Those underwear that have lips on them that Kimberly Mobley testified, those are IS's. You heard that testimony. Those underwear are a large. IS was a small. She was tiny. She was thin. Never even heard of someone upsizing underwear before. It's absolutely ludicrous. She wasn't pregnant at the time in February of 2018 when these underwear were purchased. You don't upsize underwear. That's not what happened. Those are not her underwear. And the testing done on it shows that there was no evidence, no DNA on that to connect that to IS. Similarly to those two bras that Mom says, oh yeah, those look like hers. There's no DNA to connect those to her either. None of those items found in the landfill that they pulled out could be connected to IS in any way. Terry Parker book. You heard from Ed Schmalfeld. I'm going to talk about him a little bit more later. I just want to mention it right now. He told you that items get dumped there from all over. But where did he tell you about the clothing? He told you Goodwill dumps in that same area. He told you that he saw clothing. Officer Lillard didn't want to admit that. Oh, the only clothing we saw were these. But what did Schmalfeld tell you? No, there was clothing. Detective Bidlick. I'm going to go into some of this later, but Detective Bidlick is the one who wired Morris McClendon. He's the one who set things up, told Morris McClendon, we've had several cases together. You know what to do. You know what this is about. And then Detective Abbott. Detective Abbott, on this stand, admitted to you all that without the confessions and the conversations with his brother, there was no evidence, no physical evidence to connect Mr. Quiles to the murder of IS or unborn child or any sexual battery. It was through those confessions, statements to his brother, that led them down that path. And guess what? Once they heard that, there was no further investigation. There was no further looking into anything. They didn't question Mr. Quiles to find out what was going on. Mr. Quiles' brother told them about that confession. He told them, I don't believe him. He told that to police at the very beginning. That wasn't something he just came up with when he came and talked to you all yesterday. He's been saying that from the beginning. You also heard from Dr. Atchu. Dr. Atchu is the one who confirmed IS's pregnancy. And what did she tell you? She said she was looking down. IS was looking down. She couldn't really get a read on her. She made a note about wanting to speak to her next time she came into the office alone, and to tell that to the front office at the beginning so Kimberly Mobley, her mom, would not come back. She noticed signs of abuse. And that wasn't just related to her being pregnant at 16. Rachel Thomas. Rachel Thomas told you. IS reported that she was a virgin, and her physical examination was consistent with that. She said, maybe there was something there, I wanted to get a better look at it, not sure. She never got a chance to look back because she did not get a follow-up appointment with her. But based on what she saw, she wrote in her report that what was reported by IS was consistent with her examination. Laura Draga, that was the evidence technician who did ballistics on the gun. No evidence that that gun was used in the commission of this crime. None. Only thing she could tell you was what? The gun works. It was preserved with preservative oils. She never stated that it was cleaned. She said that the oils that were left over looked like the type of oils that you use to preserve a gun. Regular usage. And then Nicholas Kutu. You heard from Nicholas Kutu. The majority of the evidence that you heard from him not related to this case in any way, except for those pill bottles. Those pill bottles came back with whose DNA? Kimberly Mobley's. Those pill bottles were found where? In SS's closet. 4 months after IS went missing. What did Naomi Mobley tell you? I've never seen those at my house. No other DNA is on that besides Kimberly Mobley's. Nothing to connect Mr. Quiles except for what besides what S has said. The credit union. Oh, let me go back. Those underwear from the rape kit with Kamar Humphrey. I want to be clear what he told you all. He could not tell us definitively if it was from 2 donors or 3 donors. He said he put both because he was not sure. If it was from 2 donors, there is no connection to Johnathan Quiles whatsoever. None, assuming 2 donors. The credit union custodian that came in. The card was used several times, and you saw that. Several times after IS is alleged to have been murdered. No longer able to use that account. There was a transfer, an internal transfer done on that account. The other internal transfer said what next to it? Nancy Ware, correct? That is what was put on there. Those transfers were done by Nancy Ware. This internal transfer does not have that information. Who was the other person who had access to that account? IS. There were some charges after that as well. Some games played. Those charges are on IS's own account, and Nancy Ware did not testify to using that account at all. I'll remind you of a few things that you heard from Johnathan and Gary Lindros. John Quiles was a great worker. Went above and beyond, would do what was necessary, saw something that needed to be fixed, he would do it. He's working diligently, never noticed anything out of the ordinary on those dates in question. You heard from about Google location. What were you told by several witnesses? He Googled Fastenal. Fastenal is a place to go buy parts. Detective Abbott told you that. Well, yeah, those places where you go to buy parts, same kind of parts that we used at Ace Pick-A-Part. Johnathan and Gary might not remember asking Mr. Quiles to buy parts. That was a normal part of his job when they needed him to. And he went to Fastenal that day to buy parts. What else did they tell you about this area that was kind of restricted in that area at that time? They told you that where he was going, they did have cars that were for storage. They had a dirt and gravel pile that he would use for work purposes to fill in ruts and fix roads. And they were also fixing a fence back there. You heard Detective Abbott talk about that. There were several reasons to be in that area. After returning from buying parts for the business on company time, Mr. Quiles heads into that area. Completely normal. In fact, Gary Lindros said, it looks like he just parked right outside of the camera's view. They can't tell you whether he went into some secluded area or anything like that based off of that video. All you know is that he goes into that area for a few minutes. And that's supposed to be enough time to do what? Teams of people worked to process vehicles at Ace Pick Apart. You see Mr. Quiles picking up a vehicle on the 20th. What did Gary Lindros tell you all? Oh yeah, that's going to go get processed. Team of 2 people come and they do the first part. Take off this, empty the trash. Team of 2 people then go do this. Take it to the crusher, do this, remove the battery. All that process of production that he told you about. That wasn't a vehicle that just gets crushed and nobody takes a look at it. That vehicle was processed just like normal. And why was that the only vehicle that got moved that day? You've been told several times. It was raining. What did Gary Lindros tell you? He said, on that day, if people weren't able to work, they went home early. When did Mr. Quiles leave that day? Around 2:45 p.m. It was hard to work in the rain out there. There wasn't a whole lot that they could do. No problem. Go home today. Using that bucket versus the forklift. When first talking about that, he's like, it's a little strange. Then when asked, okay, well, doesn't he have to fill ruts in the roads? Doesn't he have to fix the road lands? Oh, yeah, okay, yeah, there's dirt and gravel over there. That makes sense. It's a totally normal function of his duties, things that he would do on a regular basis. I encourage you all to look at those videos. You'll see Mr. Quiles walking around, talking, doing his job, going in and out of the office, getting things for people, doing his job as he normally would. Look at him and see if you can tell his demeanor. If he looks like he's suspicious, as if there's something going on. I would submit to you when you look at that, looks like he's working. Talked to you about Ed Schmalfeld a few seconds ago. Clothing items. Clothing items from Goodwill are dumped at that landfill. What else did he tell you about that search? That 16-day search at the landfill? He told you they went through 5,500 tons of garbage. He told you the dimensions, and I can't remember it. He told you the dimensions, 20 feet deep, 3 to 4 acres wide, if I'm not mistaken. He told you he overestimated to make sure that that dumpster that they were concerned about was included in that search. I asked him, would that 5,500 tons of garbage, would that have met your overestimation to include that? He told you yes. Yes, he believed so. They searched. They did not find anything. Billy Brown. Important information from Billy Brown. They only dump at the Otis Road landfill. They don't dump anywhere else. When you're listening to that wire and you're wondering, is what he's saying truthful? He's talking about Trail Ridge landfill. That's not even a landfill that American garbage dumps at. He claims that someone told him that from American Garbage. I would submit to you that he's making that up. The other witnesses you heard from. Damian Hatch. Damian Hatch claims that in 2022, February, let me be specific, he arrived in the same dorm as Mr. Quiles on February 11th, 2022. Started going to a Bible study that Brother D, Ulysses Dixon, runs. Started going to that Bible study on a daily basis. But you know who wasn't going to that Bible study? Mr. Quiles. You know what Damian Hatch told you all? They were going to that Bible study every day together. What did Ulysses Dixon tell you today? That's a lie. They're lying. Damian Hatch is lying. Mr. Quiles and Damian Hatch, Dino, as he's called, never attended Bible study together. Mr. Quiles didn't even go to that Bible study until the end of 2022, maybe the beginning of 2023. And how did Ulysses Dixon know that? He said he'd been trying to get him to come. Really good guy, doing trustee work, helping out people, but he wouldn't go to church. Ulysses didn't get anything for coming here and testifying. He even told you he was actually worried that's going to hurt him. But he came here to tell you all the truth. Tell you all that was a lie, what you heard from Damian Hatch. George Jackson. George Jackson told you all that he was not in control of the wire device. You heard at the beginning of that wire, it jumps. It jumps a couple of times in the beginning. You don't know when it's being turned on. You don't know when it's being turned off. You don't know when it's being restarted again. Mr. Quiles, you heard this from George Jackson, was left alone with Morris McClendon. Morris McClendon, who is an expert at doing these things. He knows how to do what he needs done. He knows how to get information in the way that he needs to, by whatever means necessary. George Jackson wasn't in there when Mr. Quiles and Morris McClendon were having conversation. But what do you hear at the beginning of that wire? There's razors on the floor. Talk about a razor again. It wouldn't take much to threaten someone, to get them to say what you need them to say. Think about what you heard. Every answer is prompted. It's led. They're feeding information. They're telling him, signaling to him what needs to be said. What did Mr. Quiles' brother tell you? He makes up stories. He's known for it. He is known for coming up with elaborate, wild stories. Joseph Quiles told you, in the family it's a known thing. He did it when he was younger. He was caught supposedly high. Instead of telling his mom, oh, hey, just tried it out, he said, I'm a full-blown drug addict. He was sent to a drug rehab program for a year and kept up with that. He was never a drug addict. What did Joseph Quiles tell you? He said he was the only person in that drug rehab program who tested negative for drugs the entire time. He never had drugs in the system. But that's what he knows of his brother. He knows him to run on with these stories and go on even to his own detriment. He told you, if you ask him a question, he's going to give you an answer because he can't help himself. When he gets into character, he commits. He's going to perform for you. He's going to give you that story. He's going to keep it going. That's what Joseph Quiles told you. Carol Ann Clipp. Why do we call Carol Ann Clipp? You've already heard some evidence that activity was going on IS's accounts after the date the state alleges she was murdered. But not only that, she was seen. Carol Ann Clipp saw her the day after Christmas. She saw her walking. Carol Ann Clipp has nothing to gain by coming here. She didn't want to come here. But why? She told you why. She said she called because she believed in her heart and mind that that was IS. That was the right thing to do. Same reason she came and testified here today. Kamar Humphrey. I've already talked to you about him. But he lied. He admitted he lied about his whereabouts. Just about a month ago, not even a month ago, he denied even having sexual contact with IS. Why? You've already been charged and pled to a felony battery, so why would you lie? Why would you try to distance yourself from that? Because you got asked? You didn't want to be asked what happened? Again, nobody forced him to say the information that he said. What else is he lying about? Kamar Humphrey and IS communicated via Snapchat. He told you that. Now, of course, he wants to make it seem like they didn't communicate for that long. He's not dumb. He's not going to sit here and say, oh, yeah, was in communication with her for months and months and months. Oh, yeah, we had a sexual relationship for months on end. But guess what? IS told her best friend that that was the case. They had been in communication for months. They were in a relationship for months. IS was in love with him. Jose. Who is Jose? Hispanic and black male, or mixed, 20 or 21, living in Azalea Ridge Apartments. Willie Sawyer told you all that Jose was in these apartments. The state talked to you about a puzzle. They said each of these pieces, and they gave you a little graphic, each of these pieces going to add up. When you look at all the evidence, you weigh the evidence back and forth. Are those puzzle pieces really all there? Or are there things missing? Are there puzzle pieces from another type of puzzle that don't fit? Are you forcing those puzzle pieces in? Or does it truly make sense? Because let me ask you, if IS is murdered at Ace Pick Apart, December 20th or December 19th, there is zero evidence of a crime occurring at Ace Pick Apart. No blood, no DNA, no cameras catching this happening. She's supposed to have supposedly been there overnight. According to Joseph Quiles and this supposed confession, he tried to strangle her and then left her there. Does that make sense? She just sat there waiting on him to come back? So much of the story doesn't make sense. Where is the physical evidence of this crime occurring at Ace Pick-a-Part? How could someone be shot in the chest, bleed, and there be no evidence whatsoever? He said to his brother he did it in the yard, or that comes out on a wire. The yard is where everybody works, not some secluded area off to the side. How could you do this in the middle of the day where everybody's working and no one notice anything? There are people working in teams all over that place. You heard Gary Lindros tell you. There are people working in different stations, spread out around. You'll see the video, review those videos. You'll see people coming in and out all over the place. It's a busy place. I think he said that they see 300 plus people a day. On the weekends, it's more. That many people going in and out and all over the place, and no one notices anything? There's no physical evidence whatsoever? You heard on a wire that she was put in a bag. You heard Joseph Quiles tell you, oh, she was in a carpet. Can't have it both ways. We're just making up details now? So much of it does not add up. You'll see video of Mr. Quiles driving the forklift with a bucket without a bucket. You can see into the bucket. You can see on those camera angles. Look at that video. It doesn't make sense the way it's been told to you. Question that evidence. See if it does make sense to you. Let me talk to you a little bit about SS and her testimony. SS's testimony is rife with inconsistencies. She's changed dates. She's changed what's happened, how it happened, when it happened, how many times it's happened. She went from saying there was nothing at all that ever happened to describing in her own sexual abuse story of several occasions. But originally, what did she say? She said, nothing happened at all. I don't know anything about Jose. She was asked these questions on December 19th and December 20th. She was asked several times by police, hey, tell us about that conversation that you had with your sister at the picnic table. Tell us what happened. She kept saying it was nothing. So many inconsistencies in her statements to you all. So many things that now she can't recall. I don't recall. I don't recall. I don't recall. You don't recall the things that you don't want to admit. SS is the only person who has said there was some code name for Johnathan Quiles. And what did she tell you about those code names? She actually added one. She said, oh yeah, he was also known as Eugene. SS's testimony is contradicted again and again and again by her own words. Why, if your sister is missing, would you not tell police everything you know? Everything you possibly know. Same thing goes for the family, because according to Naomi Mobley, December 6th, they were saying Jose was Johnathan Quiles. That didn't even come out to police until December 27th. Why would you wait 2 weeks after your sister is missing to say that type of information. She was protecting her? That's her excuse? That's her reasoning? She wasn't telling the truth. She had been told to say what she said. SS says she was told her sister was going to stay with her grandma, and that's why she didn't say anything. She knew immediately, she learned almost immediately that IS was not at her grandma's house. Her grandma, Nancy Ware, was informed. And yet, she still didn't think to say anything. But, oh yeah, by the way, I'm being sexually abused, and I've overheard my sister, and I know that Jose is Johnathan Quiles, but I'm not going to tell anybody that information, because that's protecting my sister. What other information did she withhold? She waited 4 months to talk to police about alleged sexual abuse. She waited 4.5 years to ever mention that she, on one occasion, was laying on a couch and overheard Johnathan Quiles and her sister having sex. 4.5 years. That never came up. She actually never even reported that to police. That was something that was said in a deposition. When they couldn't find IS, sister group is circling those allegations and accusations. They turned to SS. You're malleable. Go along with this narrative. This fits it. Now, all of a sudden, this family is, oh yeah, we knew. Oh yeah, we saw the signs. But nobody reported anything for weeks. I saw this terribly inappropriate hug. I didn't like the way he looked at her. But you all did nothing? The hard part with SS is so much to keep track of, so many things to keep straight, so many stories to try and line up. It's hard to keep track of all of that. Inevitably, you get caught up. Let's talk about those pills that were found 4 months later as well. 4 months after IS goes missing, Don Quay and parsley pills are found inside Kimberly Mobley's house, inside SS's closet. Naomi Mobley testified that her Amazon account was used. But what else did she tell you? She said, I had Amazon on my phone and on my laptop. This was in October of 2017. Mr. Quiles' femur was broken. He was recovering. IS and SS and their siblings would come over to the house. They'd help out. They had access to their Aunt Naomi's laptop. She said that they would use it often, play games. She claims no one had her password to her Amazon account. The Amazon account is up on your computer, and it's not signed out. You can have access to it. And we know that they used her laptop. Her credit card is saved to her Amazon account. All you need is for that Amazon account have not been signed out, and anyone could purchase whatever they wanted on that. And don't forget whose DNA was found on those pills. Think of all the physical evidence that's been listed out to you. It's not connected to Mr. Quiles. There's no DNA that comes back to him. There's no DNA that comes back to IS. Let me talk to you about the red van. The red van was a family car. No one's denying that Mr. Quiles drove that car or anything along those lines. But what did Naomi Mobley tell you? She said, I told him to get rid of these cars. Our house is looking like a parking lot. So what car is he going to get rid of? A broken down vehicle? His Durango that he's put a ton of money into and Naomi Mobley described as his baby car? Or the vehicle that she said, don't sell my car? There's only one vehicle left to sell. Nothing nefarious about that. This is the logical vehicle to sell when they needed some money. The video surveillance. The video surveillance from the dates that IS is alleged to have been murdered are so critical. The area that the state alleges Mr. Quiles took IS is right in an area near a fence that's opened. A fence that's opened and you can see from the office. Gary Lindros told you, oh yeah, you can see right into that area from the office windows where I sit. Not only are there people working there, not only are there people fixing a fence, but it can even be seen. That area can be seen from the office. And this horrific murder is supposed to have happened right under their nose? A person's transported in there and kept there overnight and nobody notices? What did he tell you? He said, that's not even likely. Highly, highly unlikely for that to have happened. Not that anything isn't possible, but I'm just asking you what's probable. Police didn't investigate this fully. They set their sights on Mr. Quiles. He was their target. All the tips and leads and other possible routes they could have gone, they left hanging. They failed to properly investigate. They failed to follow up and check to make sure. The state gave you a list of things that they believe prove premeditated murder. But I would submit to you that those very same things are contradicted left and right. Mr. Quiles' own words contradict himself, especially for somebody who makes up stories and elaborate and goes on and on with it, especially if he's been threatened to provide information about something he didn't do on a wire so that Morris McClendon can make a case. They claim that cameras, his activity at work, is going to prove something. I submit to you it doesn't prove anything. The fact that he left work, he had a legitimate reason for leaving work. And if he's on company time, it's no surprise he didn't clock out. I asked him if he went to go buy parts, would he have clocked out? He said no, he'd still be on the clock. Now, as you all are weighing the evidence, questioning it, we ask that you would hold the state to their burden. that burden that we've talked about so many times over the last couple of weeks. Each and every element of the crimes charged must be proven beyond and to the exclusion of every reasonable doubt. I've gone through with you tons of reasonable doubt, tons of questions, things that don't add up, things that don't make sense, that leave you plenty of reasonable doubt that Mr. Quiles committed the crimes that he's been charged with. Talked about that puzzle. How many of those pieces have reasonable doubts to them? Because each piece of that puzzle that they showed you should be proven beyond and to the exclusion of every reasonable doubt. All the elements, all of the pieces, they have to fit together. And I would submit to you that when you look through, you weigh the evidence, you're going to find those doubts. As you come back to that, if you're left with that question, if you're not certain, if you don't have that abiding conviction of guilt, that is reasonable doubt. You all have options here. You have options for the first and second counts. There are lesser includeds. So if you believe, even after looking at all of the reasonable doubt that's been presented to you over the last 6 days of testimony, Mr. Quiles committed this murder, look to his words then. He talked about it being a spur-of-the-moment thing on the wire, not something planned out. That's the difference between first-degree murder and second-degree, that premeditated portion. There are lesser included options for you all if you get there. But I would submit to each of you that when you weigh the evidence, when you go through, when you question what has been presented to you, and you determine what's reliable and what is not, I submit to you that you will find Johnathan Quiles not guilty. Thank you.
Members of the jury, feel free to stand and stretch if you would like before the state gives their rebuttal. I'll do it with you. That makes you feel better.
Here's the little thing. I actually exit out of it, don't I? Out of it, right?
State whenever you're ready.
Thank you, Your Honor. May it please the court,
Yes, sir, of course.
counsel, ladies and gentlemen. Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. In 1770, the second president of the United States, who was a lawyer at the time, said those words, John Adams. He stood in a courthouse not like this one, not with air conditioning, not with our comfortable seats. and stood up for hours in front of a jury of people. And he said that. One of our greatest founding fathers, who helped wrestle with and create our founding documents, as this court so eloquently said, right after we picked a jury, to this day, we're still adhering to that great document called the Constitution, written in 1787. Facts are stubborn things. Here's a fact. The defendant confessed 3 times to killing Ione. That's a fact. And what's even a more important fact to note is the similarities between those statements of gentlemen that do not know each other. Joseph, who lives in New York, gave consistent facts about what happened. They go point out one. Oh, well, she's wrapped in carpet versus she's put in bags. All say she shot. All say she shot at Ace. All say he summoned her there somehow. All say she's pregnant. All say he wanted that baby dead. The consistency of those 3 consistent confessions should make me sit down right now and give you this case. And stop insulting your intelligence. Because those 3 facts, to match like they did, of 3 gentlemen that do not know each other, have never discussed anything before. One's in jail. These other 2 guys, Maurice and George Jackson, on a wire. And some man in New York who's the defendant's brother never confers. Ever. Those 3 confessions mesh. That's a fact. And it's stubborn. And it's hard to argue around, but you just heard it. Counsel gets up here and says, well, there's holes in the state's case. The only holes came from this man right here. Those hands right there, he scooped up dirt or covered up dirt. Wrapped her up. Whether it's a carpet or whether it's 2 bags, doesn't matter. We don't have to prove that. He told all 3 of them he put her in a dumpster at work. And they just happened to get that right? It just happenstance? Don't let the defendant get away with holes that he created. He tried to get rid of the body. He tried to get rid of the blood. He tried to go shoot his gun. Make it look like he shot her recently. You know, he couldn't kill her anywhere else. You know why? Because his wife and him share their location. If he goes running off way out on the west side or out to Bayard or out to wherever and dumps her somewhere, she said, we share our data. And guess when his is off? Guess when his cell phone is off? Guess when he leaves work? Guess when this happens? Guess when he lures her from Terry Parker? It lines up with the cell phone data. It lines up with her data. She has no communication whatsoever. She leaves Terry Parker at 11:05 a.m. Guess when he leaves his work? 11:15. They could come up here and argue, well, he ran an errand at work. That's a 25-minute ride. Where are the other extra 53 minutes? That's why we had Detective Abbott testify to that, to show he most certainly had time to go meet with her. But the defendant, he made a grave mistake. even though he tried to clean up, even though he tried to get rid of evidence, even though he tried to get rid of the body, even though the Don Quay is on his wife's account. By the way, it doesn't, listen, if the girls got on the mother's account, which they did not, there's no evidence of that. Okay? If those girls got onto that account, where did they get that idea? The Snapchat alone tells you there's a lot of sex going on between the defendant and IS under everybody's nose. But he's the one sneaking around doing that with IS. It's a horrible secret to put on a 14 and 15-year-old child. It's despicable. Despite that, despite all the Snapchat messages that he chooses to communicate with them on, that automatically deletes. But he doesn't talk to his wife that way. He talks to the nieces that way, both IS and SS. And oh yeah, now he's taking a run at another niece, ID. Guess how he spoke to her? Snapchat. He knows how to delete evidence. But he made a grave mistake. He ran his mouth. And he told his brother. Facts are stubborn things. And that brother sat here yesterday, and he, the defendant, put him in a horrible position. Just like he did with SS and IS. But you can say all day long, as counsel just tried, well, he didn't really believe him. We picked that phone up and called the police. He said, and I'm sure you heard it from that witness stand, when he is, when I'm around him, he's confident. He's himself. And on this call, he's panicking. He's frantic. Why? Well, then out comes what he tells them. I got this girl. She's pregnant. She's my niece. I don't know what to do. I tried to strangle her. I can't stomach it. She's back in the car. By the way, they ask, the defense says, that doesn't make any sense. It doesn't? Newsflash, folks. When you strangle somebody, they can pass out. You strangle a little girl, size of that man, he can pass out in a car. And he calls his brother back on the same day. I took care of it. Listen, those are chilling words. He calls his blood brother and says, I took care of it. After just telling him, she cannot have this baby. That alone convicts him. That fact is so stubborn. So stubborn. When you add that the second confession, the wire comes along and matches it almost perfectly. Almost perfectly. You're having sex with your niece? Remember that one? Well, yeah, what about your wife? Well, yeah, she's pregnant and the doctors say she's high risk so we can't have sex anymore. We even know why he's having sex with SS and IS. We know why. You got her pregnant. It's all over the wire. Your ears got to... Listen, we apologize for the language and the things that you had to hear. Your ears heard some chilling words about right out of his mouth describing how he killed that little girl. And talk of the facts, almost like everything that you see here, they talked about. Landfill. She's pregnant. Listen, DNA in the underwear. Facts are stubborn things. We don't even have to prove motive, ladies and gentlemen, but we sure did. He could not let that baby be born. And he was determined to make sure that Hazel did it. As he said on the wire, I think it's a girl or something. That little girl's a human being. She had a name. And he killed her. Now, we're talking about puzzles a lot. My boys were little. We bought an alphabet train. The alphabet train was something it came really two ways. You have a puzzle, but they also had little cars that connected together. And little wheels on them. But they were these little shapes. They were like about that big. And they were in the shape of the letter. And you would connect them to learn your alphabet. You'd line it up on the floor. My boys did. That's how you taught them the alphabet. And each one of these had shapes on them. They had the shape of themselves, whether it was an A or a B or an H. What we just did for you is lay out all those alphabet pieces. We're asking you to put them together. What Miss Michelle just did is she took an individual letter and said, well, I'm going to take this I out, and I'm going to hold it up and say, well, couldn't it be a 1? Or I'm going to take the W out, and I'm going to turn it over, flip it over, show it to you, go, well, it could also be an M. Isn't that possible? How many times did you hear that question from counsel on cross-examination of all the state witnesses? Well, isn't it possible that? Isn't it possible this? Isn't it possible that? Isn't it possible? Isn't it possible? Isn't it possible? Do you know what reasonable doubt is? It is not a possible or speculative doubt. Then why ask those questions? The counsel comes up and says, well, there's no DNA that connects the defendant to this. Did she just say that to you? Are you kidding? What in the world is his DNA doing on the inside of these women? I don't care if that's spit, saliva, semen, touch DNA. It has no business being on the most intimate, private areas of a 15-year-old little girl's underwear in March of 2018. This alone tells you what's going on. We spent, I don't know how much time asking whether this particular DNA was, well, do you know whether it's sperm? And he said, the expert said, well, it's a sperm cell fraction. I don't care what it is. What he was certain about was that it was the defendant's DNA on the interior. You hear what he said? A yellowish stain? Now, come on. It wasn't enough to tell us whether it was a sperm cell or a blood cell or a saliva cell. That does not matter. That's trying to create possible doubt. That is not reasonable doubt. And Nicholas Kotu, he explained it. He says, listen, he goes, it's just not enough to call one way or the other. And he spent all this time on it. And he says, listen, it was a sperm cell fraction. That's what he said. But setting all that aside, what the defense just did with that DNA is they held it up and go, well, it's not really a Z in the alphabet. If you pick it up, pull it out, turn it on its side, it's now an N. That's not what your job is. Your job is to take all of this evidence, put it together, and render a true and just verdict. Ladies and gentlemen, that evidence right there is the most inculpatory piece of evidence that exists on the face of the earth. And it existed in a place the last place a 33-year-old man's DNA should be is in a 15-year-old girl's underwear. And then they bring up, well, these Snapchat. Counsel says, well, it's only half the the way the records came in. We got half the conversation. Listen, you can read it 100 times, and there's no other conclusion. We were asked, and we made it clear, please use your common sense. You can't read those Snapchat messages and draw any other conclusion rather than it was between this defendant right there. No other way to read it. He names her. He uses the sister's nickname. He uses your aunt. He uses one time about the whole kiss goodnight. Oh, well, kiss you goodnight. I'm in your house. It's clear. If that's not who this is, then this defendant and IS have an exact similar scenario going on at some other house somewhere else, and there's some other girl named Naya, Maya, Ayana. Folks, that makes no sense. None. And then counsel makes a big deal out. Well, Naomi asked him, hey, what are you doing? I'm on Snapchat. And she says, well, it's no secret. Well, you know what she didn't do? She didn't go over there and say, listen, husband, let me look at your phone and make sure that's what you're doing. She didn't do that. Ever. Then they argue, well, there's no body, there's no blood, and all the... Listen, we established she does not exist on the face of the earth, and we know it took a long time. And we greatly, greatly appreciate your patience. You all have been, as the court said repeatedly, your attention has been unbelievable. Your promptness, your attentiveness. But let me make this perfectly clear. We had to do that. In homicide cases, usually body laying there. Okay? This is a homicide case. We had to establish the body doesn't exist. And we did that. Not one shred of existence. Counsel can get up here all she wants. Says, well, there's more charges on that account. Go look at them. Did you remember what they said in the opening statement? Well, she went to Wendy's that day. She went to Wendy's that day. Mr. Davis sat right here and said to you in opening statement, remember what lawyers say, that's not evidence. When I had the custodian on the stand, tell me about that Wendy's trip. Oh, no, that wasn't December 19th. Look in the body of the transaction. It's December 13th. It was posted on the 19th. Why are they up here saying that to you? Reasonable doubt is not a forced doubt. Then why say it? They got the same records we do. Why come in here and ask questions about this Wendy's? Oh, well, no, that wasn't on the 19th. She made that perfectly clear. Then they make, well, there's no blood. We talked about that. He got rid of that. There's no murder weapon. Yes, there is. Yes, there most certainly is. Why? Number one, because he said so not once, not twice, but 3 times he said so. Here's my gun. He even talks about it extensively on the wire. Yeah, the police hadn't even gone and got it yet. They start laughing about it. Are you kidding? This girl is thrown to trash, and he's laughing about the police hadn't even gone and got the gun yet. Counsel in the opening statement, they just argued it again. Oh, the state's assuming this happened at Ace. The state's trying to make this into their crime scene. The state's not doing any such of a thing. The state pressed play on a wire. And that's what he said. That's what their client said. He said it to Joseph. He said it to Damian Hatch. Are you kidding? Is the state just sitting over here and we're just dreaming stuff up? He said it. And they have, the state's assuming Ace is the scene. Really? I killed her at work over off in a remote area over there. Put her in bags. Put her in the trash. But they take this video and they say, oh, well, you know, if we're taking the B out of the alphabet. We're holding it up going from afar. It kind of looks like an 8. Right? That's what they're doing. That's what she did in her whole closing argument to you. Pulling pieces of evidence out and isolating and holding them up to you and say, well, this isn't really a number 1. It's not really a letter I, it's a number 1. Are you kidding? Three different times, I killed her at work. And they're telling you, they're assuming where he killed her was an ace. Use your common sense. Now they bring up this red minivan and they say, well, there's no evidence in it. You know, the state, what else is he supposed to sell? All his wife asked Naomi Mobley said at the time, I said, we got too many cars in the driveway. You pick which one. And he sells the one that you see he goes to work in every day. He sells that one. And I got news. You can sell a broken down car. What do you think Ace Pick Apart is? What do you think car lots are? What do you think junkyards are? You can sell that other Dodge. He picks the one that was used in getting that girl Ace Pick Apart. And shortly, she told him that like mid-December. It was sold in like 8-9 days. Got rid of that pretty quick. And then counsel argues about that. Well, what else? What else can he sell for money? Broken down cars. You can get. That wasn't even the issue. You heard Naomi under oath say, "No, I just wanted too many cars out there. Our driveway was looking like a junkyard." Then she really took a lot of time picking on IS in her testimony. Ladies and gentlemen, let me make this perfectly clear here. For the defendant to put a 14-year-old girl in the situation he put her in is despicable. The weight that was on that little girl's shoulder, she knew what was going on. She's not going to tell. Then she says, oh, Naomi pulled them both aside and said, is anything going on? The defense wants you to believe that both these little girls go, yeah, we're having sex with your husband. Are you kidding me? Is that realistic? Or again, are they trying to force doubt on you and create this forced doubt? You bet those little girls carried around a horrible secret. It put them in a situation that no 14-year-old knows how to handle. And she says, well, once she figured out that she didn't make it to her grandma's, why didn't you tell SS? Folks, again, the answer is very simple. She's carrying around a secret that's like, oh my God, if I tell, I'm going to lose my sister's friendship. She's got to be run off with him. Maybe he's got her in a hotel. Who knows? There's so many ways for a 14-year-old to interpret that. Oh my gosh, imagine that SS's position that she was in. SS is saying to herself, if I tell, I'm going to forever lose my relationship with my sister. And she's missing, oh, please come home, please come home, please come home, please come home. It's a horrible position that he created. He did this. Now they want to come in and go, SS should have disclosed this quicker. Easy for them. Then we hear, I think they took a shot at Dr. Atchu. They said, well, she's looking down at the floor. She looked concerned. I think there was testimony she wasn't talking. If she wouldn't make eye contact, Dr. Atchu's the one that confirmed the pregnancy. Listen to this. You know what Dr. Atchu said? 22 weeks, 5 days pregnant. That's huge. Why? 22 weeks and 5 days backwards of December 13th, which is the date of the appointment, was July 7, 2018. You know what July 7, 2018? There was a family get-together. When they came back from, do you remember, way last week? The two little girls went and spent time with Grandma Nancy Ware up in Columbus, Georgia, come back. SS goes home. IS, on that night, for 2 nights, went to spend the night with him. Wow. That's why the family blew up in early December 18. They figured it out. Then they up here criticizing. Miss Michelle says, well, you know, these aunt, grandmother, I don't like the way he hugged her. I don't like the way he looked at her. Oh, they didn't do anything? Well, first of all, it's not a crime, okay, to give somebody an inappropriate hug. And it's also, I don't like the way he looks at her. That was an aunt and a grandmother. You remember those? And both said, counsel just argued to you, by the way. They didn't do anything about it. Yes, they did. The grandmother went to Pam and said, don't let him around the nieces anymore. You remember that? Those are little details that over the week and a half that you've been here, you may forget. Remember, they did do something. And number 2, don't ever question a grandmother's intuition. I learned that a long time ago. The grandmother walks out to a backyard at a family function, and it's just the two of them, the defendant and IS, and he's startled, he pulls away, and it made that grandmother concerned enough to go tell Pam, not about the hug, but hey, listen, you probably want to keep him away from the girls. You need to give permission if he comes over, and you need to be watching out. They did do something about it. They just tried arguing to you that they didn't, and they did. Forcing doubt. Don't forget the timesheet. This timesheet up here with the defendant, listen, he leaves for an hour and 13 whatever minutes. He doesn't clock out. And you can say, well, it's the parts run to the store, whatever. What about those 53 minutes? Another. He knew what he was going to do. Told his brother he'd been planning it for months. He knew what he was going to do. He blended in at work. Violated company policy, as I asked both the Lindroses. If he leaves for a long period of time on a personal issue and leaves and doesn't clock out, is that allowed? That is not allowed. I think they made a couple more arguments about, well, you can't ever see IS on the cameras at A's. Of course not. Of course not. What is the expectation that, listen, well, he's going to put her on his arm and just go walking through his work with his 15-year-old girl? Are you kidding? 16-year-old girl by that time? Of course not. You bet she's not on the cameras. But what does he say on the wire? Them cameras are crappy. You heard it. George Jackson. Yeah, it's crappy camera systems. I know where the cameras don't show. They really argued to you also about the landfill and the clothing. I was just touching on this briefly. But listen, when the detective, who's got, 30 years of experience, Detective Shannon Lillard, she's worked major crimes, homicide, crime scene unit detective, when she says, look, I was out there every day. I know what I saw. They want to throw, well, Goodwill dumps there. Got to be other clothes, right? No. Yeah, so what? Ed Schmalfeld said that there's Goodwills there. That doesn't necessarily mean that the area that they were checking had clothes. And by the way, these clothes, isn't it odd? Forget the fact that it's Victoria's Secret that Mom says, yeah, that's hers. Forget that. It's found in the same isolated area. It's a big area, don't get me wrong, but the same area that the engineer, Ed Schmalfeld, says, this is where you need to search if that's when that truck came here. 20 feet down, these 2-3 acres. What's in that 20 feet down, 23 acres? More Victoria's Secret underwear. By the way, it's not in bad shape. Okay, people don't just throw that. It's expensive. People don't just throw that out. And isn't it odd that it's there near a Terry Parker book? Oh, don't forget this. This is the trashiest of trash. Ace pick-apart paperwork in the same area. What in the world is Ace paperwork doing near a Terry Parker book, near clothing as Victoria's Secret items? What is that stuff doing there? And they keep saying, no evidence, no evidence, no evidence. This is evidence, this is evidence, this is evidence. Yes, Ace pick-apart dumpster was dumped there because you see stuff like that. We also know this little girl packed a whole bunch of Victoria's Secret stuff. We know that. It's missing from a room. We know that. That's there. Does it have to be the same size? So she grabbed a pair of her mom's or her sister's or whatever. Does it matter the size? It doesn't matter the size. There's a Terry Parker book there. What's that Terry Parker? Of the 50 or 60 schools in Duval County, the Terry Parker book is there. Folks, all this evidence screams at you. It screams who did this. The circumstances show who did this. The evidence, the phone, the Snapchats, and I haven't even mentioned the wire in this statement, or the statement to his brother. The circumstances alone show who's in trouble. He got his little niece pregnant. The motive is there. Then they call Kamar Humphrey, right? They call Kamar. Well, we didn't get along in the depot. That was clear, right? And then he says, I lied to you. Then I come up and I'm like, wait, you lied to her. You weren't getting along with her. But I'll tell you what, didn't you get on the news? They didn't bring it up. The defense didn't bring it up. We did on cross. Didn't you get on the news pleading for the public to come forward with information about this girl? Yeah, yes, sir, I did. And they call him. Now that wire, we're not going to look through all this. Let me just make this very clear about the wire. There is only one conclusion to draw from listening to it in its entirety. We apologize, 2 hours, but you had to hear it. It is littered. It is filled with incriminating statements that lead to one conclusion. Here's a couple examples. Man, if the body's dumped with book bag and stuff, then it's easier to find the defendant. No, it was all separate. This is straight from the defendant. When my wife got pregnant, she's so high risk, they cut us off from sex. Why not get rid of your gun? That's in there. You heard it yesterday. Well, it's registered to me, but that's all taken care of. I took it and shot it at the gun range to blow off steam. Didn't need to blow off steam that much because, as his wife said, he slept like a baby after she disappeared. Whole family's in a tizzy, and he's curled up sleeping like a baby. That's offensive. So he went and blew off steam. Why? Thought he got away with it. Boy, that pressure was coming down. You see it in those Snapchat texts. Oh, you see it. A man talking to a little girl like that. Manipulative. Then on the wire, man, you cleaned it all up. Then that's what he said. Yeah, I even went to the range that day. Man, did you kill her one day and dump her the next? Yeah. Man, did you made her sit in the car when she got shot? No, she wasn't in no car. How long she been dead? Well, you know, the heat index, he went into his little Discovery Channel explanation. You remember that? He said, she's been cooking out there. She's been cooking. That little girl is laying up dead in that dump somewhere. And that's the words that come out of his mouth. She's been cooking out there. Man, where'd y'all have sex at? You sneak around? Well, yeah, random spots. Like we went riding up to the store or in a car. And counsel stood here and tried to argue they let him. Did she just really say that to you? You sat here and listened to 2 hours patiently, a long audio, and not once is there a threat. She said, there's razors on the floor. Are you kidding? They're laughing it up. 98% of the time of that audio, they're just sitting back talking, casual, hanging out. Man, well, how'd you get rid of the body? There's laughing going on. And they come up and argue to you, again, trying to force this doubt. Folks, that's you know what to do with that. So I come to a close, talk a little bit about that Don Quay and the parsley. Listen, it's not just like the confession. You can say, well, listen, I'm going to be frank with you. One confession alone convicts him with these circumstances. One of those alone is enough to prove beyond any doubt who did this. For your ears to hear a confession and get a confession from a blood brother is just that much more compelling. But think about these pills. It's not just the fact that these pills existed. They were ordered on the defendant's wife's account, and she came in here and swore under oath. And let me tell you, convincingly so. I didn't order them. Did you notice the count on these? These are 100 counts. Both of them. When the detective collects them, they put every one in here. There's nowhere near 100 in these. And they're sitting at the top of the closet of the victim, IS. And they tie back to one account. The defendant and his wife's. By the way, she's pregnant at the time. You catch that? She doesn't need these. Who are they for? It's clear who they were for. Then they come up and ask you, well, you remember Barbara Johnson? She's with Gun Gallery. You don't know whose signature's on this form. Well, it says Johnathan J. Quiles. There's his signature. Yeah, but you don't know he signed it. Forcing doubt on you. Trying to create possible doubt. So I call Naomi Quote. Miss French and I call Naomi Mobley to the stand. We walk it up and show it to her. Is that your husband's signature? That's his signature. Why are they asking these kind of questions to you? And by the way, the whole thing about Ace and like, how does he know this property so well? How's he going to do this with all these people around? He knows it better than everyone. Why? Don't forget that map. The Lindroses say he brought us this map unsolicited. He'd only been an employee here he'd only been an employee there for about 90 days. So somewhere in the middle there, they said he brought this map, showed all the weaknesses in the fence. He's been all over the back of that property. Joseph Quiles, he took the stand and he testified, these are the things my brother told me. I said, sir, do you want to be here? No. You love your brother? Yes. I'm going to describe the brother like this. There's a quote from John Wayne's biographer. A guy named Scott Eyman, E-Y-M-A-N, and he wrote that John Wayne is this kind of a man. Quote, he had a spirit that makes firemen rush into a burning building. because it's the right thing to do. End quote. Joseph Quiles did the right thing. It was the right thing to do. Joseph Quiles broke one of the strongest bonds that exists on earth. And that's a brotherhood bond. He came into a court of law and he raised his right hand and he said, this is what he told me. I couldn't stomach it, so I shot her. I had to get rid of that baby. Counsel stood right there and tried to get him to say, well, you don't believe that. You don't believe that. You bet he doesn't want to believe that. But he sure as heck picked up that telephone on January 8th of 2019, called the police. On January 8th, 2019, remember this, and calls the police. On January 10th, 2 days later, you heard the words right out of his mouth on the wire, matching what Joseph Quiles testified to. Taking the witness stand and doing the right thing. And I asked him why. I said, Mr. Quiles, I said, you tell this jury why you're doing it. He said, it's the right thing to do. We don't tolerate use of women in our family. I wanted the police to have this information so they can go look for her and maybe bring this family peace. Joseph Quiles' testimony alone convicts him. With all these circumstances surrounding and all the evidence that surrounds that confession, that alone convicts him. Lastly, the defense just argued to you that we don't have any evidence, right? They stood over here, there's all these holes in it. Look at your video board and look at the evidence that you've heard in this trial. I'm not going to read every one of those to you. There is a mound of evidence here. There is evidence overflowing here. There is evidence that will bring us to phase 2 of this trial. There is evidence that the defendant is guilty of first-degree murder of I.S., Ayanna Sawyer. There is evidence that he is guilty of killing her unborn child. Proved beyond a reasonable doubt. And there is evidence we have proven beyond a reasonable doubt that sexual battery occurred on I.S. by the defendant. That presumption of innocence that you have done nothing but adhere to and pay attention so attentively, you can now just strip that off of them. This case is now where it belongs, and that's with the people. We talked about those 3 branches of government when we started this, the judiciary, the executive, and the legislative, but it's the people that make decisions. It's the people, you as a jury, that brings justice, which is so needed in this case. We now ask you to go back and convict him of all 3 counts, guilty as charged as to all 3, and carry us to phase 2 in this trial. On behalf of Ms. French and myself, we thank you for the last week and 4 days. Thank you, Your Honor. Nothing further.
Members of the jury, I'm going to give you a break before I read you the jury instructions and charge you in this case. It's 3:49. Come back at 4:15. I'll read you the jury instructions again, and we'll go over timing, scheduling wise, about what you guys want to do tonight, however long you want to stay, your verdict takes, and we'll certainly abide by those wishes. So I'll see you guys back at 4:15. A nice break. Or the jury's outside our presence. I still have counsel for the State Defense, Mr. Quiles present. Anything we need to handle during the break from council? All right, you guys can have a seat, of course. I'll see you guys back at 4:15. I'll charge them, and like we talked about, I'll tell them they will be here as long as they want tonight. I'll let them know that we're more than happy to order you dinner if you want. We're more than happy to break at whatever time you want to come back tomorrow. So it's really going to be their call. They said they can stay later tonight. We'll see what they decide to do at that point. But I'm going to charge them and send them back and see what they decide to do and maximize our time together. So appreciate you guys, and we'll see you back at 4:15.